Hi there, this is Neal Corkery, the Chairperson for the Standard Forms Committee for 2024, and I'm here to give you the June update for SFAR Standard Forms. As a reminder, you can always email the Forms Committee at forms@sfrealtors.com. Again, that's forms@sfrealtors.com. The update for June will be released on June 25th and consists of changes to some of the Copa forms, a modification or enhancement of one of the questions in the San Francisco seller disclosure, as well as one new form addressing a disclosure obligation for short-term owners of real property that goes into effect July 1st. Up first, we have some changes to our Copa forms, in particular Copa number 4, the intent to sell notification, and Copa 11, which is the notice or election to withdraw property from sale. Both of those forms previously had a list of email addresses included in the form that you could block copy and paste into an email for the purpose of having a convenient way to communicate with the various qualified nonprofits, QNPs, that are approved by the city. We were doing our best to keep up with the ever-changing email list, and having to coordinate that through our various forms platforms proved to be difficult as the city pushed additional small changes out through the system. And so the modification we've decided to make is to implement an external email list, which I'll demonstrate for you in just a moment. Specifically with Copa 4 and Copa 11, you'll see that the block of email addresses has been deleted. And instead, we now have a sentence that says, I have obtained the most recent list of SFARs from SFAR's website on, and you would fill in the date which you pull the list, and you say to yourself, well, where is this list? And there's a link now built into the form you can click on that will pull up the SFAR list of nonprofits that are here, as you can see. Now, I want to point out a couple things. The first thing is that there is an effective date here on the list. This is not the date that you fill in on the form, but this date of May 7th, for instance, in this example, should correspond with the list of the qualified nonprofits on the Mayor's Office of Housing website. So again, we have May 7th here, and we have May 7th here. We're in pretty good shape. The block of email addresses is now found in another article in the knowledge base that's maintained by the association under the service notification list article under standard forms. We open that up, you'll see again a link to the mayor's office list, the most current update date, and assuming that these two line up, go ahead and click on this little triangle to expand the list, and you can now select all, copy, and compose a new message, paste in the email addresses, compose your message, and attach the relevant forms to serve on the QNPs. This modification allows us to keep our list current as well as this email block more current. I would ask that if you're a practitioner and you happen to go in and you notice the dates aren't lined up, that you shoot an email to us. Again, the email address is forms@sfrealtors.com, and that way we can quickly update. We will, of course, be monitoring it, but very often it's a practitioner who discovers this and wants to get back to us. All right. The other COPA form that's going to receive a modification is the COPA list of nonprofit organizations and COPA procedures. This form is substantively the same. We have removed the list. Again, I just demonstrated how you can pull up the list, and the link is here. We made some small changes to the language, but other than that, this form is not changed. All right, the next updated form is going to be our San Francisco seller disclosure, which has a modified question number D, like dog, 15, which you can see is highlighted in red here on the screen. And so this relates specifically to periodic inspections of decks, balconies, stairways that are exterior attachments to property. And you may well already know that San Francisco has an ordinance that addresses this type of inspection, and there's a process in place for that. Well, the state has also passed several laws that are similar, but just different enough to make things complicated for us, to address similar concerns with these types of attachments to buildings. And so specifically be aware that this inspection requirement currently applies to uh, condominium buildings with 3 or more units or multifamily properties with 3 or more units. Everyone should remember that, of course, TICs with 3 or more units is just another way of saying a multifamily property with 3 or more units. So the first question is this property such a property? Yes, no, or don't know would be a possible response. Presumably the owner of the property knows how many units are in the building. If so, if it is, the answer is yes, then have periodic inspections which are required for certain types of attachments per certain laws. Have these inspections been performed? Yes, no, don't know is an option. And again, the purpose of these questions is to help trigger a reflection on the part of the seller to be aware that there are these periodic requirements. If they're in a condominium where there's a homeowners association, they may not be the party that's responsible, so they might not know. But this could, of course, trigger the opportunity for a buyer who's reviewing the disclosure to ask the question about this inspections. It may act as a trigger for a seller to perform the inspections. The purpose of this is not to necessarily make you the agent responsible for explaining the nuance of this, because admittedly, it is complicated. What I do suggest is that you consult with an inspector who is qualified to do the inspection, and those people will become the resource for answering many of the questions that have to do with the type of inspection and what sort of paperwork may need to be filed. If the seller is in possession of any of the inspection reports or affidavits, then we encourage them to attach copies so that those can be reviewed by a prospective buyer. And the final update is really a new form, and this deals with what are termed short-term owners. And it's a special disclosure obligation for folks who have acquired title to property that's subject to this ordinance, residential 1 to 4, within the last 18 months. And I think you will probably hear from various people referring to this as a quote unquote flipper law, but there is some nuance to that, so we want to make sure that you are aware. The form itself consists of an advisory that highlights the particular code section that would be that the properties may be subject to. Keep in mind that it is the same code section that covers the RETDS, the Real Estate Transfer Disclosure Statement, and therefore some of the same exemptions will apply. If you have an exempt seller, they are exempt from completing this form. That said, for a person who has acquired title to the property within 18 months, so that could be somebody who purchased the property with the intent of improving it and reselling it, or it could be somebody who inherited the property and gained title to the property that way. And in some instances, somebody who acquired title by switching ownership structures, so from an entity to their individual name. These folks all may be potentially subject to these disclosures. So keep that in mind. That's why we're not necessarily calling this a flippers disclosure. The next piece of it is they're required to list any quote unquote improvements that were made to the property since they acquired title. And that piece of it is already very substantively covered in our San Francisco seller disclosure, which very handily covers even folks that are not that are exempt sellers, because it's part of a requirement as part of our contract. And then, but in addition to the normal types of disclosure around improvements, or permits pulled, what kind of work was done, what did you do, what did you discover, things like that. The additional requirement is that contact information for any contractor who was hired by the seller who did work with a value exceeding $500, that their contact information be provided so that a prospective buyer can contact them to find out about the work that was done. In addition to that, there's an obligation that certain documents that are already generally provided as part of disclosure with the San Francisco seller disclosure be turned over. So that's the advisory part of this new document. The disclosure piece simply provides space for the seller to perform the obligatory disclosure piece, including providing the contact information for those contractors. And then later on, there is a copy of the code section that covers this new requirement that spells everything out, as well as a clarification on what the definition of a single-family residential property is. So those are the big changes for June. I really appreciate your time. Again, if you have any questions, you are welcome to reach out to us at forms@sfrealtors.com. And other than that, I hope you have a great day. Thank you.